Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I am Ross Simon from Maserumule, and in today's episode we shall unpack what if an employee tests positive for cannabis at work? What are the applicable legal considerations and implications? As we always do, let us start by setting out the background leading up to where we find ourselves today. On the 18th of September 2018, the Constitutional Court handed down its much anticipated judgment of Minister of Justice and Constitutional Development and others v. Prince, which legalized the private use and possession of cannabis. Since the Constitutional Court's decision, it has become a well-known fact that it is not a criminal offense for adults to cultivate, possess and use cannabis in the privacy of their homes. For the purposes of this What If episode, we shall discuss the recent landmark judgment in the matter of Enever v. Barloworld Equipment South Africa, in which the Labour Appeal Court determined the appropriateness of a dismissal based on the employee's breach of the employer's zero-tolerance approach to possession and consumption of drugs and alcohol in the workplace. In this matter, the employee Enever had been employed by Barloworld Equipment South Africa since April 2007. At the time of her dismissal, she held the position of category analyst. The employee practices a zero-tolerance approach to the possession and consumption of drugs and alcohol in the workplace. This practice is contained in the Employee Policy Handbook, and by accepting and signing the handbook, the employee agreed to random, voluntary and scheduled drug testing. During April 2019, and in response to the Prince case, the employer sent out a document titled "Cannabis is strictly prohibited in the workplace." In the document, the employer stated that while cannabis use was decriminalized for adults in the privacy of their homes, the decision would not have any bearing on the zero-tolerance policy regarding the possession and use of cannabis because the workplace was not a private space. After the decriminalization judgment, the employee began to use cannabis to reduce her reliance on prescribed medication for severe anxiety, as she saw improvements in relief from cannabis-based products without any of the side effects. Accordingly, the employee began smoking a cannabis cigarette every night and on weekends, along with daily use of cannabis-based products like cannabis oil. During January 2020, the employee was required to undergo medical testing to regain biometric access to the workplace. The employee's results were positive for cannabis, and accordingly the employee was denied access, sent home, and instructed to return after 7 days. By the end of February 2020, she had been subjected to at least 4 tests, which kept returning positive results, indicating that the employee did not stop using cannabis. Disciplinary action for ultimately testing positive for cannabis and failing to test negative as required by the policy then followed, which resulted in the dismissal of the employee on the 30th of April 2020. After a dismissal, the employee referred an automatically unfair dismissal and an unfair discrimination dispute to the Labour Court, in terms of which she alleged that the employer had unfairly discriminated against her by applying the zero-tolerance approach, and therefore her dismissal was automatically unfair. One of the main issues the Labour Court had to decide was whether the zero-tolerance approach in the employer's policy to testing positive for cannabis at work was unfair and discriminatory. The Labour Court decided that the policy was applied consistently between employees testing positive for cannabis and alcohol. The employee had incorrectly elected to make out a case of unfair discrimination where discrimination was not present. The employee's dismissal arose from normal misconduct, which is a matter that falls out of the jurisdiction of the Labour Court as a court to decide on the basis of first instance, and even though the employee was aware of the policy, she continued to breach it. Therefore, the employee's willful breach of the policy amounted to misconduct, and a sanction of dismissal was correct under the circumstances. The employee, unsatisfied with the decision of the Labour Court, then referred the case to the Labour Appeal Court. The Labour Appeal Court essentially had four main issues to determine. Firstly, did the employer differentiate between the employee and its other employees? Secondly, was there a direct causal connection between the employee and testing positive for cannabis and her dismissal, which constitutes an act of discrimination against her based on her spirituality, conscience, and belief, alternatively on an arbitrary ground in terms of Section 187(1)(f) of the Labour Relations Act. Thirdly, was the policy unfair and discriminatory? And lastly, was the employee's approach insulting, degrading, and humiliating, and an impairment to the employee's dignity? In determining whether the employee was subject to unfair discrimination on a listed ground, the Labour Appeal Court interpreted spirituality to be one and the same with the listed ground of religion. The Labour Appeal Court agreed with the Labour Court that the link between the employee's dismissal and the use of cannabis was not because of her spiritual views, conscience, or beliefs, in that she admitted to the court that she smoked cannabis recreationally. This was therefore sufficient to demonstrate that there was no discrimination on religious grounds. The court held that when determining whether the policy differentiated between alcohol and cannabis users on an arbitrary ground, the employee was required to show that there was impairment to a human dignity in a comparable manner to discrimination on a listed ground. Whilst alcohol and cannabis users were subjected to the same treatment by being sent home if they tested positive, alcohol users could almost always return to work the following day and test negative, provided that they had not consumed any alcohol. However, this was not equal for the cannabis users, as cannabis has been found to stay in the body for a longer period. Therefore, positive cannabis results thus does not address the soberness of the cannabis user and whether they are impaired from carrying out their ordinary duties and responsibilities. The employee submitted that she faced discrimination as a cannabis user, which impaired her dignity by violating her right to privacy, specifically to use cannabis in the privacy of her home, and subjecting her to a humiliating process that portrayed her as a junkie. Whilst testing positive for cannabis did not mean that her faculties were in any manner impaired in the performance of her duties. The Labour Appeal Court stated that the decision in the earlier mentioned Prince case, although it was not a labour matter, impacted on the nature of an employee's right to privacy, and that an employer cannot disregard an employee's right, or rather privacy, when implementing or acting in terms of its own policies. The Labour Appeal Court found that employers might have justifiable occupational health and safety reasons to bar certain conduct of its employees. However, this was not a justifiable reason for the infringement of the employee's right to privacy. The Labour Appeal Court reasoned that the use of blood tests alone, without the proof of impairment on the work premises, is a violation of the employee's dignity and privacy. The employer's policy prevented the employee from engaging in conduct that is of no effect to her employer at all. The employee was placed in a situation where she was essentially forced to choose between her job and the exercise of her right to consume cannabis privately. The employer could not demonstrate that the employee's work was adversely affected or that the employee created an unsafe working environment for herself or her fellow colleagues. The Labour Appeal Court stated that while the employer did operate in an environment with heavy machinery, the policy was unjustifiably overboard, and the same standards could not be applied to an employee who works in an office outside of the dangerous environment. The Labour Appeal Court did not accept that the zero tolerance rule was justifiable because the employer had a generally dangerous working environment, or that it was an inherent requirement of the job not to consume cannabis. The Labour Appeal Court found the dismissal to be automatically unfair on the basis of unfair discrimination and awarded the employee 24 months compensation. Ultimately, what this judgment does is that it simply reaffirms the legal stance that zero tolerance policies to alcohol and drugs can indeed restrict or prohibit cannabis consumption by employees as part of a drive to establish a safe working environment. However, it shall be for the employer to demonstrate that strict adherence to the policy is an inherent requirement of the job. Otherwise, employees should not be prejudiced in any way. Accordingly, the application of a zero tolerance approach to testing positive for cannabis shall have to be carefully considered going forward, and evidence of impairment is crucial, and much shall also be dependent on the facts of the particular matter. In closing, substance abuse policies should be drafted in a manner that will not be construed to be an infringement unjustifiably on the rights of an employee. Some keynotes. The Labour Appeal Court stressed that this finding may not be true for other employees of the employer whose circumstances and work environment may be different. Breathalyzers have been held by the Labour courts in various alcohol intoxication cases as not conclusive to justify dismissal and should be coupled with other evidence such as the employee's behavior, which is generally associated with alcohol intoxication. The Labour Appeal Court stated that a similar jurisprudence should develop in relation to the known symptoms of cannabis consumption and their effect compared to the duties associated with the nature of an employee's job. And employers relying on a substance abuse policy, intoxication must be proven, unless it can be shown that a zero tolerance approach is an inherent requirement of the job for the particular employee concerned. On the 6th of June 2024, we will be hosting a webinar on the topic and the practical considerations an employer should consider determining whether an employee has contravened substance policies. The webinar shall include a discussion on what constitutes evidence of impairment and suggestions on how to re-evaluate substance abuse policies to ensure that they are not unfairly discriminating against employees who use cannabis in their private capacity outside of work. If you would like to register for this webinar, please contact us at info@massconsulting.co.za or head over to our website at www.massconsulting.co.za. Until next time, bye-bye.